Hello friends, Namaskaram. Today we will discuss about section 482 of BNSS. Basically, it deals with the direction for grant of bail to the person apprehending arrest. Basically, it is termed as anticipatory bail. It is equivalent to section 438 of CRPC. As we know that CRPC has been repealed, and that's why we are having section 482 of BNSS for anticipatory bail. The said section allow a person who believes they may be arrested for a non-bailable offence to apply to High Court or to Court of Session for an order directing their release on bail if arrested. So basically, I inter alia gave all of you the general idea about section 482 of BNSS. Now we are coming on the legal protocols. Subsection 1 says that when any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offence, he may apply to High Court or Court of Session for a direction under section 482 of BNSS. And the court may, if thinks fit, direct that in event of such arrest, he shall be released on bail. So we could say that for the application of the said section, the prime condition is that the offence must be non-bailable. If the offence is bailable in that scenario, the said protocol would not help the accused. And apart from that, in the non-bailable offence, there must be reason to believe that he will be arrested on an accusation of having committed a non-bailable offence. In that scenario, the remedy lies before High Court or Court of Session. As far as subsection 2 is concerned, when the High Court or Court of Session makes a direction under subsection 1, in that scenario, it may include such condition in such direction in the light of facts of the particular case. The direction might be as under, please be noted. A condition that the person shall make himself available for interrogation by the police official as and when required. There might be a condition that the person shall not, directly or indirectly, make any inducement, threat or promise to any person acquainted with the facts of the case. And apart from that, the concerned person will not cause any evidence to disappear. Point number 3 is that there might be a condition that the person shall not leave India without the previous permission of the court. And clause number 4 says that there might be other conditions as may be imposed as per subsection 3 of section 480 of BNSS, as if the bail was granted under that section. So whatever conditions are provided as per section 480 subclause 3 of BNSS may also be imposed as per the protocol of section 482 subclause 2 of BNSS. Subclause number 3 says that if such person thereafter arrested without warrant by the officer in charge of the police station on such accusation and is prepared either at the time of arrest or at any time while in the custody of such officer to give bail, he shall be released on bail. So the said section simply says that in case the person is having the order and subsequently during the course of investigation he is arrested and he is ready and willing to give the bail, in that scenario he shall be released on the bail. And if a magistrate taking cognizance of such offence decides that a warrant should be issued in the first instance against the person, he shall issue a bailable warrant in conformity with the direction of the court under subsection 1. So basically, the said subsection says that if the concerned person is having the immunity as per section 482 of BNSS, in that scenario, no coercive action is required to be taken. In case the concerned official is the police official, he is required to release the concerned accused on bail, and if the concerned official is the magistrate, in that scenario, he is required to issue the warrant in conformity with the order passed by the concerned court under subsection 1. As far as subsection 4 is concerned, it says that nothing in this section shall apply to any case involving the arrest of any person on accusation of having committed an offence under section 65 or section 70 subclause 2 of Bharatiya Nagarik Suraksha Sanhita. So we could say that as far as the offences under section 65 and section 70 subclause 2 of BNS is concerned, the remedy of anticipatory bail could not be taken. because subsection 4 inter alia bar the remedy. In that scenario, remedy lies under jurisdiction of questioning or writ jurisdiction, because we are having ample citations wherein the remedy was granted specifically in those cases wherein the remedy of anticipatory is barred by the statutory provisions. So basically, as far as the key aspect of section 482 of BNSS is concerned, we could say that basically it inter alia incorporate provisions for the anticipatory bail. It provides a mechanism for the individual to seek anticipatory bail, means a bail before arrest, in those cases which are non-bailable in category. Apart from that, the application is to be filed only before the High Court or Court of Session. So at inception, we have to move before Court of Session, and subsequently we can move before Honorable High Court. Apart from that, it entirely provides the conditions for the bail, and apart from that, the court might impose condition requiring the person to cooperate with the investigation, not to interfere with witnesses, and not to leave country without permission. And apart from that, it might impose conditions as required by section 480 subclause 3 of BNSS. And apart from that, if the person is subsequently arrested, he is required to be released on bail upon furnishing the bail bond, and the said subsection 4 of section 482 of BNSS specifically bar the grant of anticipatory bail in cases of rape of a girl under 16 years of age. For this, you may peruse section 65 subclause 1 of BNS, and apart from that, it also bar the remedy in case of gang rape of a girl under 18 years of age. For this, you may peruse section 70 subclause 2 of BNS. And apart from that, if the person violates the conditions to be imposed, the court may cancel the anticipatory bail. So basically, we have to understand the set protocols while moving for the anticipatory bail. I think that I cause all of you to understand the basis of section 480 of BNSS. If you are having any query, you may leave in the comment box. See you in the next video. Till then, Jai Hind, Jai Bharat.